If your landlord does not make repairs, you can call your local code enforcement office or building inspector to inspect your apartment. You can usually contact that office or person through your town or city government. Code enforcement may ask you if you have contacted your landlord. We should also know that if the problems at your apartment are bad enough, the code enforcement office can order you to vacate your apartment immediately. This is a good reason for you to take pictures of the conditions, if it's safe to do so, before you call code. If the problem is bad enough, you might also want to make sure you can pack what you would need for at least 1 or 2 nights, such as important documents and ID, most importantly, any medications or medical devices you or your family need. Don't forget masks and/or proof of vaccination, because even when you have legal options to try to force repairs, those options will take time. For the most part, you should not be ordered to vacate your apartment unless the problem is an imminent danger. This generally means something that is currently a danger to you or your family that could result in injury. Code will sometimes order a tenant to vacate their apartment because of fire code violations, and that could include smoke detectors or carbon monoxide detectors that are missing or don't work. If you call code, they should schedule an inspection of your apartment. If they find violations at the apartment, they should notify your landlord, and they will give your landlord a certain amount of time to fix the violations. If code issues an order to vacate, they are required to post a notice on the door stating that an order to vacate exists. They will often post a list of all the violations as well. If the tenant is not being ordered to vacate, many code enforcement offices will not automatically notify the tenant. You should ask code for a copy of the notice of any violations that they might find at your apartment. Even when code does find an imminent danger at your apartment, as a tenant, you have a right to a hearing about the violations. Code may not know this or agree with this position. The New York State Department of State's office is in charge of issuing guidance and regulations for local code enforcement officers, and the Department of State has plainly said that a tenant has a right to a hearing before being ordered to vacate. If code does find an imminent danger, the hearing can be held after the tenant is ordered to vacate. If you are ordered to vacate, your County Department of Social Services, DSS, may be able to provide you with emergency shelter. You may need to bring along a copy or a picture of your order to vacate to show that this is an emergency. If code does not respond to you and/or inspect your apartment or does not give you a hearing, you can contact the Department of State's office. If your landlord does nothing and your local code enforcement office does nothing, you may need to contact an attorney. You may be able to withhold rent if you have given your landlord enough notice and a chance to make the repairs. Withholding your rent means more than just not paying the rent. You must have also notified the landlord and be prepared to potentially pay that rent if and when your landlord makes the repairs. If you do withhold rent, do not spend it. Currently, landlords can move forward with an eviction for non-payment of rent. If public assistance pays part of your rent, you can tell your caseworker about the problems in your apartment. They can potentially withhold their portion, and your landlord cannot evict for public assistance being withheld. You also have the option of making or paying for the repairs yourself and deducting the amount from the rent before you pay it. This option creates a lot of issues that are probably going to end up being decided by a court, and you should not take this option lightly. Depending on where you live, in a city versus a town or a village, you may be able to ask your local court to force your landlord to make repairs. Also, if you're able to show proof of the conditions in court, the judge may find that the apartment was not worth the entire amount of the rent and find that you don't owe the landlord all the rent they are asking for. Courts will generally reduce your rent, if at all, by a percentage. For example, a 25% reduction of $1,000 per month rent would mean that the tenant would still have to pay $750. A court will not reduce the amount of rent owed by 100% generally unless you are forced to move out of the apartment because of the conditions. You should be prepared to discuss what you think your apartment is realistically worth within the problems that you have proven exist. In order to be able to prove these problems in court, you need to print any photos you have taken. Courts generally will not consider photos that are on your phone. You will also need to prove how long the problem or problems existed. Once the judge decides the amount that your apartment is worth after a trial, you will be required to pay that amount, or the court will issue a warrant of eviction. You should talk to an attorney. In summary, document the problems, notify your landlord, call code enforcement if necessary, but be aware that you may be ordered to vacate, and consider withholding rent from the landlord, but not spending it.